All rise.
Good morning, gentlemen. First of all, you can take it that we've spent some time reading in advance, of course. And secondly, may I ask you before you begin whether you have agreed a timetable between you? I'm sure you have.
We have, my lady. Our present expectation is that I would complete my submissions before 4 o'clock today, likely about 3:45. My learned friend would then take the remainder of today with a view to finishing by about 3:45 tomorrow.
Thank you. Lovely. With that, let battle commence.
My lady, good morning. I appear in this matter for the Royal Bank of Canada with my learned friend Miss Black, and my learned friends Mr. Bremner and Mr. Ripley appear for the respondent commissioners. The court will have been provided, I hope, with the core bundle, a supplementary bundle, and what are now 3 bundles of authorities, one having been subdivided. As the court will have identified, there is a transcript being made, and it can be made available to the court if that would be useful through your clerks this evening and then after play tomorrow.
Yes, please. Thank you.
Now, assuming it's convenient to the court, I propose to address the court under 7 main headings. Let me identify them at the outset. Some observations by way of overview as to the nature of the present dispute. Secondly, to look briefly at the sale and purchase agreement by which these relevant payments arise. Thirdly, then, to look at the double tax agreement, which obviously is central to the debate between the parties. Fourthly, then, to give you my submissions on the interpretation of Article 6.2, the operative provision. Fifthly, then, to consider the application of Article 6.2 to the relevant clause of the sale and purchase agreement. Sixthly, then, to identify what we say are the errors below in relation to Article 6.2. And then lastly, seventhly, to address the UK statutory provisions, being section 1313 of the Corporation Tax Act. So that's my route map from now to 3:45.
Thank you. So we'll start with the overview.
Overview, the big picture. So it is helpful in my submission to spend a few minutes on that big picture before we descend into the detail. And again, in my submission, it's helpful to keep certain important features of the landscape in mind. Firstly, the parties to this story. So the oil exploration and extraction activities in the Buchan Field of the North Sea were carried out, when the story starts, by Sulpetro UK Ltd, which I refer to as SUK or SUKL. They then, in the events that happened, came to be carried out by BP, then a company called Talisman, and then later a company called Repsol. Those later companies are not germane to the dispute between the parties. But significantly, the oil exploration and extraction activities were not carried out by the bank, I'll refer to as RBC. RBC itself has never had any oil exploration or extraction activities in the UK continental shelf. The court will have identified that a non-resident company can be deemed to have a tax presence in the UK if it has oil extraction activities in the continental shelf by virtue of a particular part of section 1313. RBC is not within that provision. Instead, RBC has a banking trade in Canada. It has a London branch, but the relevant loan at the start of this story that was made to Sulpetro, the parent company, was made in Canada by the head office of RBC. It was not made by the London branch. So relevantly, when we come to consider the application of the double tax agreement, it is as if RBC doesn't have a banking branch or a banking permanent establishment in the UK. And under Article 7 of the treaty, as we'll see in a little while, this means that RBC is not taxable in the UK on the banking profits of its head office. Instead, RBC is taxable in Canada on its banking profits, and it is, in the events that have happened, taxable in Canada on the sums in dispute here. The revenues say, however, that RBC is also taxable in the UK because what RBC receives is income from, quotes, immovable property under Article 6, which the UK can tax by virtue of Article 6 and has taxed by virtue of Section 1313 of the Corporation Tax Act, in effect, so as to tax RBC on oil profits from the UK continental shelf. The end result, in the eyes of the Revenue and the Upper Tribunal, is that what is taxed in Canada in RBC's hands as a profit of its banking trade is also taxed in the UK as oil profits. Now, one of the reasons the Revenue used to explain such a conclusion is that the payments that were made here by the UK-based oil companies, originally BP and later Talisman, have been treated as tax deductible in the UK by the Revenue. So in the UK, there are sales proceeds of oil that are taxable income of, say, BP, but the Revenue have allowed the payments by BP to RBC to be deducted.
That's not just a claim to deduction, but it has been accepted?
It has been accepted. Now, I have a point as to whether that was right or wrong, but it has been accepted.
You're not going to ask us to decide if that was right or wrong?
I'm not. But such payments are also taxable in Canada. So looking at the big picture...
Sorry, which are also taxable in Canada? The oil?
The payments that are in dispute under clause 5.4 are taxable in Canada.
Yeah, yes.
So looking at the whole picture, again without descending to the detail, we have a payment that is treated as tax deductible in the UK, and it is taxable in Canada. And there's nothing, we say, inherently wrong with that result. That's how tax works on many cross-border payments. But the Revenue's stance is to say, however, that's not good enough. The relevant payment should also be taxable in the hands of the recipient, RBC, in the UK, and I would add, as well.
Well, you say as well, but that was a characterisation of the Revenue stance. And the Revenue stance, presumably, is that if it falls within Article 6, it doesn't fall within Article 7, and therefore it's the Canadians who got it wrong by taxing it in Canada.
Well,
I don't think the Revenue are saying this really ought to be taxed twice, are they?
Well, that's the result of what they say.
I understand that, but I don't. But you said this was the Revenue stance, that it should be taxed here as well.
Well, the Revenue stance is it should be taxed here.
Yes, they don't. They don't
I was
care
careful
about
to add, and I say, as well, because that's the effect of what happens. Because this is, in Canada, in Canadian terms, is a taxable receipt of the banking trade.
Yes, but if the Revenue are right, does it not logically follow that the Canadians shouldn't be taxing it?
My lord, no, because under Canadian domestic law, this is just a profit of a Canadian banking trade.
Yes, but before you get to domestic law, doesn't Article 7 carve out from your profits of an enterprise anything that falls in Article 6? Well, I misunderstood that.
No, my lord, that's the effect of the treaty.
Yes.
But the treaty, the Canadians see this as being Article 7, and the UK stance is this is Article 6.
It may assist that Article 6 does not provide that the relevant territory is the sole taxing entity. In other words, tax under Article 6 in the UK would not by itself preclude tax in Canada.
Again, if one stands right back, one can see there's a mismatch of perception, or a mismatch of characterisation, because in Canada it is just seen as a profit of the banking trade, and because it's a profit of the head office of RBC, it's taxable in Canada. The UK see it as taxable under Article 6 in the UK. And how they get there is in two stages. I anticipate the court has this, but just for clarity. The argument against me proceeds on the basis that first, you treat the relevant payments as income from a particular type of immovable property under Article 6, and that confers taxing rights on the UK. Having done that, the UK then taxes them as the receipts of a deemed oil trade under Section 1313. So the revenue stance has to move from characterising it in one way for the purposes of the treaty and then characterising it in a different way for the purposes of the domestic statute. Now, the question of this court, is that right? First tier and the Upper Tribunal against me say yes, we say no. Second point by way of overview, the double tax agreement itself, so the debate between the parties in large part turns on the proper interpretation of the treaty between the UK and Canada, and we'll need to look at the relevant provisions in due course in the context of the treaty as a whole. But anticipating a submission I'll make in a little while, one needs to construe that treaty in light of its context, its purpose, and as a whole. So as regards the purpose, clearly one of the main purposes of the double tax agreement is to avoid double taxation. And here we know such sums are taxable in Canada, and the revenues say are taxable in the UK. And that construction of the treaty and the UK provisions undoubtedly produces what is double taxation. Now, the detail doesn't matter, but the effective tax rate faced by RBC in relation to these payments varies from year to year, but it's up to 88%, bearing in mind the high rates of oil profit taxation in the UK, which have ranged up to 62%, and roughly 32% corporation tax in Canada. Now, that I recognise might be correct. But this court does need to look very carefully as to whether that is the right answer, because the result that is produced is contrary to the main purpose of the double tax agreement entered between the UK and Canada. Two further features of the background that it would be useful to identify now. Firstly, the ring fence. Oil profits are taxed in the UK within a notional ring fence as a deemed separate trade. So you'll see reference to a ring fence or a ring fence corporation tax charge. Oil extraction activities are regarded as being a single trade, and where the oil is within the UK continental shelf, or indeed the UK itself, then it's treated as being a single deemed trade within that ring fence. And it's that ring fence that allows the application of higher rates of tax to oil extraction activities, so higher than the mainstream rates of corporation tax. There is a difference now. The difference is slightly narrower if you ignore energy profits levy. But at the moment, the rate of tax for North Sea activities is 40% plus the levy, when mainstream corporation tax is now 25%. That disparity has been greater in the past. So it's that ring fence that allows the special rates of tax. It also allows for special allowances and reliefs to be conferred on oil exploration activities. Now, the revenue below have complained, in a rather graphic phrase, that there's a hole in the ring fence if these payments are not taxed in the UK in the hands of RBC. Now, what is said to be a hole, the so-called hole, is the direct result of the revenue agreeing with BP and later Talisman that the payments made to RBC are deductible in computing ring-fence profits. Now, there was considerable discussion dating back to the mid-1980s between BP and the revenue as to whether such sums should be deductible. The revenue apparently agreed at the time that that was right, although there is material in the bundles where it's tolerably clear by 2014 they were rethinking and regretting that But what is said to be the whole is the product of the revenue's historical decision, I would say historical mistake, to treat the payments made to RBC as being deductible. But it's no answer to that so-called whole to distort the meaning and application of the double tax treatment and the relevant UK statutory regime in order to levy what we say is double taxation on RBC itself. Secondly, and more importantly, the revenue stance rests on an assertion, unspoken perhaps, that economic activity in the UK continental shelf must be taxable in the UK. And as a general principle, that might be right. One cannot answer the dispute in this appeal by reliance on such a general principle. Instead, one has to look to see what the UK has agreed with the relevant other sovereign state in the particular double tax agreement concerned, the effect of which is that not all profits that have a relevant link to one contracting state are necessarily taxable in that contracting state. So there are plenty of instances where one contracting state gives up, by agreement, what might otherwise be its claim to tax particular economic activity, but that is a product of negotiation between one sovereign state and another. And that is what has happened here. And one can't describe that exercise of sovereignty by the UK in its treaty negotiations with Canada as a whole in the UK tax net. Instead, it's just simply an agreement by the UK that not all economic activity in the UK is necessarily taxable in the UK.
It's the design of the net.
It's the design of the net. Now, the countervailing proposition is that not all economic activity in Canada is necessarily taxable in Canada. It's just what the parties have agreed. And we'll come back to that in a little more detail. Second other feature, just to identify at this stage, is the relevant contract by which these payments are made. I'll come to that in just a short while. But the court will have in mind that the payments are made, were made originally by BP and later by Talisman under clause 5.4 of the SPA that was entered into when Sulpetro sold various assets to BP. I'll develop this very shortly, but the structure of that deal was heavily influenced by the regulatory regime that operated in the UK continental shelf in the 1970s and the 1980s. So oil was discovered in the North Sea towards the end of the 1960s. The extraction and development of the North Sea as a basin doesn't really get going until the early 1970s. And the UK doesn't have any special tax regime for oil extraction in the UK continental shelf until 1973. So the forerunner of section 1313 comes in 1973, and the forerunner of what's now the ring fence comes in 1975. The way the industry was structured in the 1970s and the early 1980s was that exploration and extraction was permitted by virtue of licenses granted by the Secretary of State on behalf of the Crown, and that's because oil in the UK continental shelf vests in the Crown under the Continental Shelf Act 1964. So the UK at that time wanted licenses to be held by UK companies. So that was a regulatory requirement. It was written into some regulations. But of course, a lot of the capital that was needed to develop the North Sea was in overseas groups, typically US. So a practice developed of the UK government granting a license to a UK company, and the UK company then entering into what's called an illustrative agreement with typically a US parent or a US related party, whereby that party would finance the exploration and extraction of the oil, but then be entitled in turn to the oil won. And
Do the licenses require payments to the Crown in the nature of a royalty?
they do.
Yes.
There is a...
So it's not just taxation, which is the UK's interest in the field.
The UK has an interest in extracting an appropriate economic share from the oil,
Yes.
and it does that in 2 stages. There is a royalty you must pay to the Crown under the licence for the ability to explore and then extract.
And that's the licensee who's
And the
responsible for paying.
The licensee has to pay that. There is then a tax charge on the profits made from that extraction activity, where originally there was a requirement for the companies doing that activity to be UK resident to ensure that the UK could extract its share of the pound. And we'll see there is a sample illustrative agreement where it was written in that the relevant company extracting the oil and selling the oil had to be UK resident. Now, post 1973, the UK had its particular protection by deeming you to have a branch or a permanent establishment in the UK if you were extracting in the continental shelf. And the Lord is quite right that there is a royalty obligation to the Crown paid by the licensee, and then there are separate oil bespoke tax regimes for the extraction profits. Now, we do not have the illustrative agreement that was entered into between Sulpetro and Sulpetro UK Ltd. It's just not possible to find that. We know it was entered into in November 1982. So what the parties did before the first tier was find an example, and with one rider, we agreed that that example was representative of the sort of agreement that would have been entered into between Sulpetro and Sulpetro UK. I'll show you that in a moment. But it was Sulpetro UK Ltd that held the license and had the royalty obligation to the Crown. It's Sulpetro Canada that is the counterparty to the illustrative agreement that was entitled contractually to the oil won.
Entitled contractually to the...
To the oil won from the seabed.
And just to clarify, the government wasn't party to those illustrative agreements. As far as I can see, it was just between in this case, would have been the Canadian company and the UK licensee.
The lady is correct. The government was well aware of the practice, and it was...
Presumably,
Alright.
what is being said is that the illustrative agreement must have been in a form approved by the government, hence the parties' willingness to agree that the example they found in the National Archive could be taken as what the text said.
My lady is right. I cannot say to the court that the government specifically approved the version we have, because I just don't know that.
Yes.
But the practice of the license being granted to the UK company, the finance being provided typically by a US company, under an illustrative agreement, was a practice that was known to and accepted by the UK government. And we'll see the example we've got with one rider does reflect the relevant roles of the parties, as you would expect. Now, when Sulpetro came to do its deal with BP, point I'll develop it just shortly, it sold the shares in SUKL because it was SUKL that held the license. It also sold various other assets to BP. I'll show you the agreement. And it was under that agreement that Sulpetro Canada had the entitlement under clause 5.4 to the payments, and it is that right that passed to RBC on Sulpetro getting into financial difficulties Sulpetro having borrowed money from the bank and not repaid, eventually the bank takes an assignment of all that is left in Sulpetro, and one of the very few assets that were left were the rights under clause 5.4, and for a long time those rights didn't pay out because the oil price was below the contractual trigger. And then as the oil price rose, then that right had value and payments were later made.
Do we have evidence of what the oil price has been over the last however many years it is?
There is evidence in the bundle that, I forget the exact date, but the trigger price is $20 under the contract. And I can find the reference, but that price was, the oil price was below 20 for a long time. In fact, we can find it.
And it's fluctuated up and down since.
And it's fluctuated up and down since. Until relatively recently, it's not gone as low again as 20. But I think
there was a point where it went very low recently.
But in the pandemic, technically, it went negative.
Yes.
Which is a rather odd concept. But
it cost more to store it than it was worth.
It cost more to store it than it was worth. And we can find the data so your lordship can see the progression. But for a long time, you didn't hit 20, then for a long time it was above 20, and then in very recent times it crashed back down again.
And then it's gone up again.
And now it's up about 79 or 80. Now, just as a point of detail, the agreement we're going to see provided for this right to be payable in perpetuity. It wasn't time limited. Buchan started production in 1981, but production ceased at Buchan in 2017. Although, having checked on the website yesterday, somebody else now owns the rights in Buchan, and there was a suggestion now the price is high enough again, they might try and revive Buchan. But RBC's entitlement to any payment in relation to that counterparty is long gone. So we're only concerned with a certain period of years, it's 2008 to 2015, in which RBC did receive payments because the oil price was high enough to engage the $20 limit. I'm told actually there is a table of oil prices in the supplementary bundle at tab 19. It's not a table, it's the last paragraph of that email, page 156.
Yes.
The relevant, this is a revenue officer, had done a quick check. Prices were just above $20 in 96, but did not climb above 20 again until late 99. It was above that from then on, and then he computes what it would have been, and this is an email exchange as at June of 14. That's a partial picture. That was the reference I had in mind, but we can provide the court with a full picture. But as you might expect, it's fluctuated above and below the $20.
But you say it came to an end in 2017 anyway?
As far as RBC is concerned, yes. We have not received any payments since then.
But we're concerned with 2008, 2015.
15. Those are the years of assessment that are in issue. But just coming back to the big picture, the question when we come to Article 6.2 is whether the right to the Clause 5.4 payments is a right to variable or fixed payments as consideration for the working or the right to work the oil at Buchan. Now, the only person actually working the oil deposits was SUKL and then later BP, because only it.
When you say later BP, is that because SUKL was collapsed?
We don't know what we don't know. We know that the illustrative agreement was novated, and I'm going to show you that. But what we don't know is what happened to that company later during its ownership by the BP group. what the court perhaps needs to bear in mind at this stage is the license is in SUKL. There is an illicit agreement between Sulpetro and SUKL. That was novated as part of the deal with BP. So BP became the counterparty to the illicit agreement with SUKL. We've called that, just for the sake of argument, illicit agreement 2. And under that illicit agreement, originally Sulpetro had the contractual right to the oil 1, and that passed to BP by virtue of the novation of the illicit agreement.
Does that mean that Sulpetro, as opposed to SUKL, was carrying on a taxable oil business in the UK because it receives the oil and sold it?
Not under section 1313, because it merely has a contractual right to the oil. It doesn't carry itself the oil exploration or extraction activities.
Right.
Now, there is a point when we come to section 1313(2), little a and little b, where we need to look very carefully about how the UK captures its asserted right to tax oil activity in the UK. But we'll come back to that.
So perhaps I wrote down the wrong thing, Mr. Peacock. I wrote down originally Sulpetro had the right to oil 1,
Yes.
and that was passed to BP.
Yes.
But that's different from working the field.
Yes.
This is the physical asset which consists of the barrels.
It's the product
Yeah.
of the working, but it's not itself the working. Maybe it'll make more sense when we look at the specific terms of the illicit agreement, but that's the agreement between the two parties.
You say SUKL's business was extracting the oil, working the license, whereas Sulpetro's business was owning and selling the product.
Dealing in oil.
Dealing in oil.
Yes.
Which is not an extraction business. It's an oil business, but it's not an extraction business.
Yes. And that arrangement was the product of the regulatory regime that the UK insisted on at the time. The license had to be in the UK company, but the capital was likely to come from elsewhere. Now, one other point just on Article 6.2 is that there is a reference there both to working and the right to work. We say that one can't work without the right to work. And so the significance of the formulation that's adopted in Article 6.2 is that it's designed to capture payments that are made for working, so computed by reference to unit extracted, so per barrel, as an example, and a payment that's made for the right to work, which might be a payment made by reference to a period of time. You might buy the right to work for a year, and you make a payment whether you extract anything or not. Whereas conversely, if you're paying for the working, you may pay by reference to so much per barrel extracted. And 6.2 is designed to capture both types of commercial deal, whether you pay by time for the right or by unit for that which is extracted. The last point to make by way of introduction is that this case is obviously a product of a very odd set of facts, whereby RBC has become entitled to payments under Clause 5.4 in repayment of a loan originally made in Canada by RBC head office to a Canadian company. And the oddity is that those profits are said to be taxable as oil profits in the UK. But the court shouldn't assume that this is just a case on its facts, because the effect of the decision of the Upper Tribunal is that payments made by oil companies to lenders, banks or non-banks, UK resident or non-resident, might now be seen as oil profits taxable inside the ring fence at what is currently 40%, rather than liable to mainstream corporation tax, currently 25%. And that might arise where the payments are computed by reference to oil price or oil production. So that does have wider impact for off-take finance agreements where projects are funded by loans, where either the interest or the principal payments are computed by reference to either oil production or oil prices. So this is at heart a debate about the ambit of the ring fence. And it does arise by virtue of a very odd set of facts. But the decision of the Upper Tribunal, and in due course the decision of this court, may well have a wider impact. So that's what I'd say by way of introduction. My second heading is to look at the SPA by virtue of which the payments arise. And it would help, before we come to the SPA, just to look briefly at the illustrative agreement. So the court has the background to this, that these types of agreements were entered into to reflect and respect the regulatory regime imposed by the UK. And here we know, for a reason I'll show the court in a little while, that in November 1982, Sulpetro and SUKL entered into an illustrative agreement. Now, the sample agreement that we have is in the supplementary bundle at tab 1. And this is entered into in 1971. So just as a note, this is before the UK has its first attempt at defining the boundary of its taxing rights in relation to the UK continental shelf. It's before 1973 when section 1313 came in. It's 1971 between Signal Oil and Gas Company Limited, which is the licensee, so SOGL is the licensee, and Signal Oil and Gas Company UK, which is a company incorporated in the state of Delaware, but with a business address in London called Signal. And the first recital refers to the fact that the licensee has applied for and expects to be granted a certain license. And in the second recital, the licensee desires and Signal is willing that Signal provide a portion of the funds and equipment necessary. Now, as we'll see in a moment, this is the difference that the parties are agreed wouldn't be reflective of the actual agreement, because, as you'll see in a little while, Signal had a 24% stake in the relevant field, and this agreement only bites on 19%, a 19/24. So you'll see reference to a part that is true of this particular agreement, but wouldn't have been true of the Sulpetro agreement. So then, over the page 5 of the bundle, section A, definitions, article 1, licenses defined by reference to the license granted and identified in the London Gazette. Signal has a participating interest of 24%, just above the second hole punch, and then there's a sentence, this agreement shall apply as to 19/24 of the said licensee's interest, so that's the part. And then over the page 6, section B, article 2, subject to law, the regulations, the license and this agreement, so that's reflective of the regulatory regime that bites on this agreement, the licensee shall conduct petroleum exploration operations in and connection with all the areas covered by the license. And if petroleum is discovered, shall develop the areas and shall produce the petroleum therefrom. So it's SOGL as licensee that will search for and produce the oil. Article 3 provides, as does the license, that the licensee shall pay the royalty to the Department of Trade and Industry. And then Article 4, footer page 6, licensee shall ensure that all petroleum won and saved from the licensed area, other than petroleum used therein for the purpose of carrying on drilling and production operations or pumping to field storage, shall be delivered onshore in the UK. And that's part of what gives the UK taxing rights, because you had to deliver the oil to the UK. Unless the Secretary of State gives consent otherwise. That was the Secretary of State saying in a pre-73 world, you have to land the oil in the UK.
Yes, so that would not necessarily have survived later changes.
It may or may not have done.
That was designed to ensure that then oil dealt with in the UK would have been subject to UK tax.
It was. That and one other provision we'll see in a moment. Section C, rights and responsibilities of signal. So Article 5, signal shall provide 19% of 100% of all funds and equipment. And then halfway down that article, licensee shall provide the remaining 5%. And then a sentence that the revenue placed some reliance upon with respect to its interest, this is the 1924th, signal shall provide the budget and work programmes which shall comply in all respects with law, the regulations, the licence and other obligations of the licensee, a nod to the regulatory regime, and such programmes shall be carried out by SOGL. And then Article 6, signal shall own and receive 19% of 100% of the petroleum won. And over the page, still in the same article, signal shall receive no reimbursement of any kind for any investment made or expenses incurred, and signal must look solely to income derived from the extraction of petroleum for the return of any capital. But the disposal by signal of petroleum won and saved shall be in accordance with the law, the regulations and the licence. Article 7 deals with information. Article 8, signal shall at all times have its central management and control exercised from within the UK, so as to be resident within the UK for tax purposes. This was requiring the counterparty to the illustrative agreement also to be UK resident, which is the other provision in a pre-73 world that would give the UK tax. And they're just reading over the page, top of page 9, the signal shall deal with the petroleum won and saved from the licensed areas entirely through contracts of sale, which are concluded in the United Kingdom.
Sorry, where's that?
Top of page 9, my lady.
Okay. Again, ensuring taxing rights
UK
in
taxing
the UK.
rights. So what you have is recognition that the license is in our terms, SUKL. It has the obligation to pay the royalty and comply with the regulatory regime. The party in the position of Sulpetro puts up the finance and has a contractual entitlement to the oil won. And it is that agreement that is then novated to BP, as we'll see. The SPA itself is behind tab 6. This is between BP Development Ltd and Sulpetro Ltd. So just pause there. SUKL is not a party to this agreement. It's the subject of it, one of the subjects of it. It's not a party to the agreement. Recital A records that Sulpetro owns SUK. Recital B records that there's going to be a sale of the shares in SUK. And then recital C and D record that there are other assets that have to be sold to BP. Over the page, just to note at the foot of 21, assets is capital T, tangible assets, Sulpetro's license interest, the data and the shares. over the page 22, Buchan is defined. Between the two hole punches, consideration is the consideration referred to in clause 4.1. That's not clause 5.4. Data is defined, information relating to the licenses, and then there's an effective date of the 1st of November, 1986, unless varied. Over the page 23, there's a definition of illustrative agreement, referring to Appendix D, definition of licenses, referring to Appendix B, and then license interests means that share attributable to Sulpetro and SUK of any and all rights and interests, whether legal or beneficial, and property to and in the licenses as is set out in Appendix B. Foot of the page, definition of production taxes. These are oil-related taxes. And then over the page, page 24, there's capital R royalty, and that's payments made to the Secretary of State. That's the government royalty. And then capital R royalty payments, slightly unfortunate piece of drafting, but those are the further payments under clause 5.4. Shares is the shares of SUK. Sulpetro's assets are the assets other than those held by Sulpetro UK. So not surprising drafting technique that whatever Sulpetro UK doesn't hold, Sulpetro is treated as holding. And then Sulpetro's license interests or beneficial rights and interests in the license is held by Sulpetro. Then there's a definition of tangible asset, which is field-related plant and equipment. And then over a couple of pages to 26, clause 2.1, this is the sale of Sulpetro's assets to BP. And that is, by virtue of the definitions, such part of the tangible assets, the license interest, the data and the shares, as is held by Sulpetro. Then there's a series of conditions precedent. Just to note 3.2, there was some correspondence between the Revenue and BP in 1986 about the taxation of this transaction, whereby one of the possibilities that was envisaged was that there was a capital gains tax disposal by Sulpetro. One of the assets that it got was the right to the payments, which would itself be a separate capital asset that would then be disposed of when the cash came in for the payments. And that harks back to a decision of the House of Lords in a case called Marin and Ingalls, where you get a right that you value on day one as part of your capital gains tax calculation, and then when that right fructifies, you do in effect another capital gains tax calculation. So that was one of the possibilities that was envisaged.
But that's a route which never has been taken, or?
We don't know how Sulpetro accounted for its tax on the sale.
Okay.
Sulpetro was already in financial difficulties and became insolvent. It's not a flippant. My friend's clients technically do know. It's just lost in the mist of time because they know how Sulpetro filed tax returns. But the parties now don't know.
But it doesn't affect whether the view we take, if it's relevant, of the agreement.
No, because this court has to form a view about what you think the agreement does. But there is material in the supplementary bundle that is some, although not all, of that correspondence, and one can look at it. But I don't seek to do that now, but just so that you wonder what was that correspondence and why is it a condition precedent.
It possibly sheds some light on the slightly odd fact, which you've already referred to briefly, that the consideration, definitely the concept of consideration in clause 4.1 doesn't pick up
The 5.4.
5.4, even though how else would you characterise 5.4?
Well, and without begging too many, it's a payment for something, but as we'll see in a moment, what it's a payment for is not identified.
It's called a royalty payment.
It's called a capital R royalty, capital P payment. But perhaps I'll come back then to saying, well, we look at 5.4. But
I think we might want to revisit this, but let's.
but Lloyd is right. It's called a royalty payment.
Can I be sure I've understood this point about bringing the clause 5.4 right into account for capital gains tax purposes? The revenue, presumably, is not bound by the consideration that the parties choose to state on the face of their agreement, but can say, actually, when you disposed of these assets, part of what you received was this right to future payments.
Yes, and there is a perfectly reasonable legal analysis that would treat that as a capital gains tax transaction in the seller.
And part of the consideration for the disposal would be the current discounted right for the future contingent stream of possible payments.
Yes. So if you sell tangible assets for 100 and you have this sort of right, you say, well, its present value is 5. We'll charge you to capital gains tax now on 105. But what you then hold is a right, capital right, which if that then fructifies to deliver another 20,
you pay 50.
Okay.
You tax on the 15.
You pay capital gains. No, you pay capital gains tax on the 20.
Or the base, you get a base cost.
Well, you get a base cost. My lord is right. Yes. But it's that capital gains tax disposal in 2 stages that is a. I can't say necessarily is the only right analysis, but it's a perfectly reasonable analysis based on a decision of the House of Lords in a case called Marin.
But does that mean when the 20 is paid, it's treated as a disposal of a capital asset? Is it also taxable as income? Or is it?
No, it would just be treated as capital. It's a capital gains tax event, and you bring it into charge at capital gains tax rates.
Well, I mean, that would depend on the facts, wouldn't it?
And I say, I can't say definitively that's the only way you can tax it, but that is a way it could be taxed.
But it is possibly relevant for the purposes of what we're looking at to think about how conceptually the House of Lords approached that matter in Marin and Ingalls. And the point being that the payments made pursuant to the right, the contingent deferred payments, are treated not as related crudely to the original disposal, but to the shows in action, the right under the contract. So it's one step removed, and that strikes me at least as possibly relevant conceptually to what we're.
My lady is right to say it is conceptually one step removed, and that doesn't determine the nature of what is paid, but it is clearly a relevant factor in determining what is paid, the nature of what is paid. And this doesn't strictly matter to this court on this appeal, but one of the reasons why I say the revenue should never have agreed that these payments were deductible in the payer was they were capital expenditure. They were not a revenue item. They were part of the acquisition cost under this sale and purchase agreement.
I'm sorry, I'm being very slow, Mr. Peacock. I thought the revenues attempt to tax these stream of payments was because they were income payments from an oil business.
That's what they say.
But if they're not income payments at all, then if they're capital payments, then are they taxable? I mean, leave aside all the other points that they're taxable.
What is said against me is that once you define immovable property by reference to the 5th limb of 6.2, what you get from that is said to be income in the hands of RBC,
even if it's even if you're right that it was a capital payment by talisman.
Yes. Well, one has to ask. There are always two ends. Is it capital in the hands of the payer?
Yes.
Is it capital in the hands of the payee?
And they're not necessarily the same.
And they're not necessarily the same.
Okay.
So I might make a series of payments in my business that would be revenue expenditure. I can't immediately think of a good example, but they may be capital in the hands of my counterparty, or vice versa. And there is no necessary correlation between the position of one and the other.
Well, maybe the best example is a banking trade, because all receipts by the lender from a loan would be capital in nature, but not necessarily all of the payments by the borrower who might take on that loan for capital purposes.
My repayment of the principal of a loan would be a capital payment in my hands, but for the bank it's just a revenue
receipt.
Receipt.
It's a receipt of a banking trade.
And that's perfectly applicable here.
Now, my case does not depend on this court working out how Sulpetro ought to have been taxed, because that's just no part of the appeal.
No, but it is relevant for this court to look at the SPA and try and work out what it was actually doing.
Yes, because ultimately it's the monies that my clients receive under 5.4 that are said to be 6.2 money from immovable property.
Mm-hmm.
Can I just be sure I've understood this? I understand that what is capital in the hands of the payer may be income in the hand of the recipient, and vice versa. Would you say that what might have been capital receipts in the hands of Sulpetro might still be income receipts in the hands of RBC?
RBC, by virtue of the assignment that was approved by the Court of Alberta in '93, comes to stand in the shoes of Sulpetro under clause 5.4.
Yes.
So the bank's position for the purposes of this appeal is the same as Sulpetro's under 5.4.
Does that not mean that whether Sulpetro's receipts were capital receipts or income receipts is pertinent?
Relevant but not determinative, because whilst it might have been, let's say, was a capital receipt in the hands of Sulpetro, that
it still doesn't stop it coming within Article 6? Or?
Well, I think the case against me is that may or may not be right, but it doesn't stop it coming within Article 6. Because whilst it's material that it was capital in the hands of Sulpetro, assume that that's right, it's not determinative that it's income in the hands of, sorry, it's not determinative that it's capital in the hands of RBC.
Okay, I'm not sure I've fully understood that, but I don't want to take up any more of your time.
Perhaps we can come back. So I want to look in a little detail at 5.4 and how it works. But what prompted this debate was my Lord's observation that it's called a capital R royalty payment, and it is. I quite accept that. So if there is significance in how the parties describe it, that's how it's described. Now, over the page 29, you get clause 4, and this is the capital C consideration for the disposal of the assets to BP shall be the sum, and then the version that we had been redacted, but there is behind tab 10 in the same bundle a memorandum from some advisors in Canada, dated 9 months later, that sets out what the relevant figures are. So it's page 124 of the bundle. So there are 3 redacted rows on page 29, and the first 3 rows of that table on page 124 are the figures.
These are sterling figures.
They are, yes, beginning L for pound sterling. And the parties have proceeded below on the basis that one can read in the figures on page 124 into page 29. So there's a sale of Sulpetro's assets other than the shares and license interests for 16.8 odd million. The license interest is 250,000 and the shares in SUK are 10,000. Now, there's then provision in 4.3 for what happens if the effective date is the closing date, and there were various additions and deductions from the capital C consideration. I don't think anything turns on those for now. Over a couple of pages to clause 5, page 32, there's an obligation to pay an advanced petroleum revenue tax payment. That's clause 5.1, and that figure is also identified on page 124. Now, we're not interested in that, but that's what that is. And then 5.2 is various balancing payments in the event that the effective date is 1st of November 1986. And again, there were various adjustments to that effect. Over a couple of pages, 5.3, audit and insurance payments, again, adjustments either way. And then 5.4, subject to clause 5.4.2, with effect from the effective date, BP shall, in respect of each quarter, pay a royalty to Sulpetro in respect of all production from Buchan and Humbly Grove. Now, Humbly Grove is a UK onshore field. No payments were ever made under that part of the clause. So Humbly Grove falls out of the picture. And then for each quarter, a royalty rate per barrel in US dollars to be applied to actual from Buchan and Humbly Grove respectively, calculated for each field in accordance with the following formula: 50% of A minus B, where A is the actual market value, as hereinafter defined, per barrel of petroleum production from Buchan, and then less royalty and production taxes payable per barrel. So it's 50% of what you actually get on selling the oil, less royalty and production taxes, minus B, the notional market value per barrel of such petroleum production on the basis of $20 per barrel. Again, adjusted for royalty and production taxes. So it's the net of tax actual sale proceeds less $20 a barrel times 50%.
I don't think that quite captures it. It's net of tax actual proceeds less $20. What your net actual proceeds would have been had it been $20 a barrel.
Yes. And there was some debate between the parties about how they would actually do that calculation. And just for your note, there's a letter behind tab 7 where BP write to Sulpetro, no, my paraphrase, but they say, how are we going to do this calculation? Can we agree on various things? And they're listed on page 113 and 114. That is responded to by Sulpetro at tab 9, pages 120 and 121. The parties envisaged signing a separate agreement to reflect their agreement. But so far as we can tell, that didn't happen. And one can see that at tab 11, page 128. So detail perhaps doesn't matter, but tab 11, page 128, last year BP and Sulpetro discussed proposed amendments to the said agreement, which were aimed at clarifying the provisions relating to the royalty payable to Sulpetro by BP. Although the companies reached agreement on the principles of such amendments, no formal agreement was executed. And they drafted a letter agreement that would formalise that, and we do not know whether that letter agreement was ever entered into. But how the parties thought they were going to do that calculation appears from those exchanges in those tabs 7, 9 and 11.
And Sulpetro was already in receivership in July 1987. So.
It was. And just coming back to 5.4, 5.4.2, that's 36, makes clear that there's only a payment to be made where A is greater than B. And clause 6.1.2, page 37, makes clear that BP had to do this calculation each quarter and provide details to Sulpetro. And then 6.1.6 makes clear that this had to be done in dollars, and if there was a need to convert, then they identify the rate for conversion. And then it's 6.2.1 that provided for payment within 14 days. The way it was designed to work is that BP would sell the oil produced from Buchan and then do a quarterly accounting, depending on whether the price was above or below $20. Clause 8.1 provides for what's going to happen at closing, which was expected to be the 1st of December. And 8.1 envisages that the parties will enter into the novation agreement set out in Appendix G. And it was 8.5 that required the payment of capital C consideration under clause 4.1. And then just quickly, the license interests are identified at Appendix B, which is page 59 of the bundle. The tangible assets are identified at page 63 of the bundle. There's a schedule of associated agreements at page 66, and on page 67 you'll find a reference to the offshore illustrative agreement dated 19th of November 1982. So that's how we know it was entered into in 1982. And then there is provision made for a series of novations in Appendix G, but the relevant one is at page 99, and this is the offshore illustrative agreement novation. And what you find here is a draft of the novation of that illustrative agreement by Sulpetro to the BP counterparty. And one can see that from recital C on page 100. So what the BP company got, BP Petroleum Development Ltd, was it acquired the tangible assets and the data and Sulpetro's license interests and took a novation of the illustrative agreement, the effect of which it entered into illustrative agreement number 2 with SUKL. And what the BP company also got was the shares in SUKL, where SUKL itself held the licenses. The upshot of that is that BP and SUKL were parties to the second illustrative agreement, and BP owned the company that owned the license, and BP, by virtue of that second illustrative agreement, had a contractual right to the oil won. And the last step in the history is that the bank, in part repayment of the loan then outstanding, still outstanding, took an assignment of the the rights under clause 5.4, that assignment being blessed by the Court of Alberta in 1993.
Just going back to the agreement and the point we touched on before, the stated consideration is in clause 4, and broadly the amounts stated there. And then there's this clause that's headed other payments, which obviously includes clause 5.4 and other payments, without expressly stating that it's in consideration of anything, but can only be, surely, in exchange for the assets that BP acquired.
That must be right, my lady.
I think I might have picked up from the correspondence that there might have been some deliberate drafting going on here with a view to certain desired outcomes, but in reality, the payments under clause 5 must be consideration.
They're clearly consideration under this sale agreement. They are given by...
Well, at least the rights, the commitments given under clause 5, that's more accurate, are part of the terms of the deal and must be part of the
They are part of the terms of this deal, yes. Yeah. My lady has perhaps picked up, there is a suggestion that BP were keen to maximise the capital allowances they got. So they were keen as to how the consideration might be apportioned. But there is no express apportionment of any of the identified consideration under. There's no apportionment under of the right to the payment under clause 5.4 to any particular asset transferred by Sulpetro.
Well, indeed, it tries to. The way it's written is as though that's completely self-standing and not in consideration of anything.
That is how it appears on the face of 5.4, but I quite accept, I don't think it's disputed, that it is part of the deal that was done by the BP company and Sulpetro. Our best view of what was really going on here is that there was a right to the oil one under the illustrative agreement that was novated to BP, but at the time the parties did this transaction, they did not know how valuable that right was going to be, because that depended entirely on future oil prices.
Okay, so yes, it's not. It wouldn't be illogical to associate the clause 5.4 right to the novation, rather than to the assets, the other assets.
The other assets, so the tangible assets and the data, one could, and the parties did, put a number on them. The unknown was the value of the right to the oil one from Buchan, going as long as Buchan lasted. The parties agree a payment stream in perpetuity, it's not time limited, computed by reference to an oil price of $20. The valuable right, but with an unknown value, is the benefit of the right to the oil one. We then say the better reading of this contract as a whole is part and parcel of the deal as a whole, yes. The better reading is that this right under 5.4 was given for the novation of the illustrative agreement.
And the illustrative, or the benefit, if you like, of the illustrative agreement isn't otherwise picked up in the sort of concept of assets and license interests and so on that's listed in clause 4.1.
It's not.
I see.
And insofar as there was value in the oil field, it was the illustrative agreement which gave the value, because the value is not in SUKL. It's got a license, if you look at its accounts, it's not a valuable company, and it's only got £10,000 attributed to it. The reason it's not a valuable company is because although it has the right to win and work the oil, neither has the capital to do it, nor the right to the oil once it's won.
Correct. And it carries all of the obligations as license holder to comply with all of the regulatory regime.
Yes, except it's got a contractual right to have Sulpetro give it the money to do that.
Yes.
And as I understand it, unlike the illustrative agreement we saw, where the licensee was responsible for 5/24 of everything, under this assumed illustrative agreement, Sulpetro was responsible for 100% of everything.
Correct. Yeah.
So that does mean that the UK company, although it's for regulatory purposes the license holder, doesn't have anything of real value. It's got the license, which is obviously valuable, but it's not something that you put a capital value on, because it doesn't enable it to keep any of the oil.
It has a license that in the abstract you might say, looking at the projection for what's going to come out of Buchan, it might be worth 100. But as license holder, you've got the obligation to develop Buchan, and that might cost you 95 or 120, and you just don't know. But it has the benefit of a contract, originally with its own group counterparty, later with BP, whereby that counterparty will provide the capital and take the oil.
And it's the taking the oil, which is where the money is.
And it's the ability to deal with the oil, which is where the money is, yes.
So that does make sense for describing the payment as a royalty payment for effectively the assignment of the rights under the illustrative agreement to BP, because that's how BP is going to get anything of value out of this package.
Yes, because ignore for a moment that BP becomes the parent of SUK. Absent the illustrative agreement being novated across,
it doesn't get any oil.
It doesn't get any oil.
It doesn't work.
It doesn't work.
And just owning the platforms, which are worth millions of pounds in terms of kit, is of no value to it unless it can use the kit to get the oil.
Correct.
So it's not artificial to say the so-called royalty payments are payments for the right to the oil.
It's the benefit of the contractual right to the oil one. Now, we say that's the better reading of the contract as a whole, accepting, of course, as I do, that it doesn't say that expressly in 5.4, but it doesn't tell us what it's for. But also recognising that the licence itself is not transferred, assigned, novated or sold.
It doesn't need to be.
It doesn't need to be, because BP Development was buying the shares in the company that held the licence.
Buys SUK.
It buys SUK.
Well, you say 5.4 doesn't say what it's for. Its own description is BP shall pay a royalty in respect of all production.
Yes.
That's a pretty good description of what it is, isn't it?
Well, my lord, we would say yes. That is what it does say. The drafter has to draw that distinction between this clause, royalty payment, and the statutory royalty or the licence royalty.
This is not a royalty payable to the Crown.
But it's computed by reference to whatever oil is eventually won to the benefit of BP Development under the illustrative agreement.
Thank you.
One other wrinkle, nothing I think is going to turn on this, but what Sulpetro held in Buchan wasn't the whole field. If you looked at the licenses, it only held a 12.7% slice. And there were other unrelated parties who held part of Buchan. But this agreement bites on 100% of 12.7%.
Everything that Sulpetro had.
Everything that Sulpetro had, yeah. So if you see a reference to 12.7%, that was all that Sulpetro had. This sort of agreement is sometimes portrayed as it's a sort of earn-out agreement, whereby you can't value part of what is being transferred, so the parties agree a commercial mechanic to share the value once that value is identified. But the value here was in the benefit of the contract being the right to the oil won. So that, I think, is perhaps all we need for now on the agreements themselves. My third heading was the double tax agreement. It's in the bundle in a couple of places. I'll need to show you a couple of iterations, but start with the very basics. The UK-Canada double tax agreement is an example of a bilateral tax treaty between contracting states by which they agree between them to allocate either exclusive taxing rights, so only contracting state 1 can tax a particular payment, or they allocate primary taxing rights. So contracting state 1 has the right to tax, and contracting state 2 can also tax, but typically must give credit for the tax in contracting state 1. So some of the provisions of the treaty are about exclusive taxing rights, some of them are primary. But the purpose of it as a whole, inter alia, is to prevent double taxation in relation to cross-border economic activity. And that necessarily means, as I said in opening, that one contracting state may give up what might otherwise be a claim to tax, where it is satisfied that it has adequate reciprocal rights by virtue of the agreement as a whole. So not all of the economic activity in contracting state 1 is necessarily taxable in contracting state 1. This sort of agreement is not automatically part of UK law. It's given effect in the UK by Section 6 of the Taxation, International and Other Provisions Act 2010. Just for your note, is in the first volume of authorities at tab 15.
Can I just pick up one point there? The tribunal decisions below, they read as though it's simply incorporated into UK law, and I don't think it may not be relevant, but it's not quite that straightforward, is it?
No, because some jurisdictions, an international treaty signed by the sovereign state is automatically part of domestic law.
Yes, but no, it's more what Section 6 does. It's certainly part of domestic law insofar as it relieves tax, but whether every part of it is automatically brought into effect is another matter.
My lady is right,
So,
but it's the point I was going to make in a moment, that one has to read the treaty remembering that it is at heart an international treaty between two
Yes.
contracting states.
it is not simply a statutory instrument.
You can't simply import it into the UK tax code as a
Yeah.
whole. It's an international treaty that brings with it various interpretation obligations I'll come to in a second, the effect of which is incorporated through Section 6. Now, the way that these things are done in the UK, Section 6 provides the gateway to the UK statutory code. They are typically done by way of statutory instrument. So can I just invite you to turn up, it's the first volume of authorities, and it's in tab 6.
Well, it's strictly done by ordering council, isn't it?
The lady is right, it's strictly done by ordering council. And so it's the 1980 order. So Article 1 may be cited as the Double Tax and Relief Taxes on Income Canada Order 1980. Just for your note, there was a further order in 1980, Order number 2. It's Statutory Instrument 1980-1528. and that gave effect to a protocol.
Sorry, give me that one again.
That gave effect to a protocol.
To a protocol. I'm going to show you it was
There's
a
more
protocol.
than one protocol.
There is more than one protocol.
Which one were you referring to there?
It's the first protocol in 1980 itself.
Yes.
And it's statutory instrument 1980, number 1528. I'll show you why that's significant in a moment. But Article 2, page 85, provides that the arrangements specified in the convention set out in the schedule shall have effect. And then the schedule sets out the convention as it then stood. And just to note, at page 119 of the schedule, page 119 of the bundle, the last article of the schedule, that records that the agreement, the convention, was done in duplicate in London in September 1978, in the English and French languages, both texts being equally authoritative. Now, there was a debate below as to whether the French text is part of English law. And we say it is, and the UT said it isn't. But the UT then went on to consider the provisions anyway. But should it be material, we say that what is taken through the order to be part of, or to have effect in English law, is the arrangement specified in the convention, where that convention is done in two languages, each being equally authoritative. And then just to note, I may want to come back to it, page 128, there is an explanatory note to the order that has something to say about what is immovable property. So about 10 lines down, as a sentence begins, provision is made for income from immovable property. Sorry, that hasn't been sidelined, but can you just sideline the next 5-6 lines, and I'll come back to that. Now, I should say in saying that I accept that it's headed, this note is not part of the order, so I know that. So that's the order itself. The treaty is in the bundle in 4 iterations. So it may help to mark on the index. Tabs 2 and 3 the index of the first volume of authorities identifies 2 is an English text version and 3 is a French text version. 2 is original in English. The ones I'm going to look at, because they cover more of the relevant years, are the versions at tabs 4 and 5. So the parties signed up to what was called the multilateral instrument that amended a lot of these agreements. What you have at tabs 4 and 5 are the versions of the treaty before that multilateral instrument. So in case it's helpful, what I'm going to look at are the versions at tabs 4 and 5. And one's in English, one's in French. So the version at tab 4, I'll come to the detail of it in a second, but and again, this should be common ground between the parties. The fact that it is an international treaty brings with it the obligations to comply with the Vienna Convention on the Law of Treaties. And that's behind tab 1. And in particular, Article 27, page 5 of the bundle, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. Article 46 is not relevant. And then there are a series of interpretative rules in section 3, page 6 of the bundle, interpretation of treaties, and it's articles 31, 32 and 33. I anticipate that courts must have seen these before. So Article 31 is a general rule of interpretation in good faith by reference to context and purpose. You should look at the preamble and the annexes. And then 31.3 provides things that shall be taken into account, including over the period at sea any relevant rules of international law. Article 32 is supplementary means of interpretation, so recourse may be had, supplementary means of interpretation, including, so it's not exhaustive. And then 33, interpretation of treaties authenticated in 2 or more languages. Where a treaty has been authenticated in 2 or more languages, the text is equally authoritative in each language, unless the parties agree otherwise. 33.3, the terms of the treaty are presumed to have the same meaning in each authentic text. And then 33.4, if there is a difference of meaning or an apparent difference of meaning, the meaning which best reconciles the text having regard to the object and purpose of the treaty shall be adopted. Now, there are a series of decisions of the courts in the UK in this court and in the court of, and in the House of Lords and the Supreme Court, addressing the relevant principles. Here quickly to turn up the second volume of authorities. Really, just by way of note, if we turn to tab 18, there's a case called Fothergill, House of Lords decision, about the Warsaw Convention on the carriage of baggage, where there was a French text and then an English translation, and the House of Lords had to grapple with the significance of the French text and what you could and couldn't look at in addressing that French text. For my part, at least for now, I'm not sure we need any part of Fothergill, but there's a long discussion in all 5 speeches in the House of Lords about that. More immediately relevant, behind tab 21, you'll find a decision in the Chancery Division in the case of Commerzbank, in particular judgment of Mr. Justice Mummery, as he then was, where he sets out the relevant principles to be adopted in interpreting international treaties, and this also was a double tax agreement. It begins at bundle page 465. Between letters F and G, he begins, before I examine the contrary submissions to the Crown, it is necessary to refer briefly to the approach to the interpretation of provisions such as Article 15, which have been agreed between sovereign states. And he then sets out a series of numbered propositions beginning between letters H and J with 1. I invite the court at some stage to read them, though I suspect the court has seen those many times before. But that exercise runs relevantly through down to page 467 at letter F. And then more recently, the Supreme Court has visited this line of country, first in a case called Anson, which is behind tab 24. This is about the interpretation of the UK-US agreement. And the principal judgment is given by Lord Reed, which begins at page 543 of the bundle. But then picking up his lordship's judgment at page 554 of the bundle, paragraph 54, he has a heading, the Vienna Convention on the Law of Treaties. His paragraphs 54 and 55 set out the provisions we've seen. And then 56 is worthy of note. Put shortly, the aim of interpretation of a treaty is therefore to establish by objective and rational means the common intention which can be ascribed to the parties. That intent is ascertained by considering the ordinary meaning of the terms of the treaty in their context in the light of the treaty's object and purpose. Subsequent agreements, the interpretation of the treaty and subsequent practice are also to be taken into account, together with any relevant rules of international law. Recourse may be had to a broader range of references in order to confirm the meaning arrived at on that approach, or if that approach leaves the meaning ambiguous or obscure. And then 57, he identifies the purposes of the 1975 UK-US Convention being to avoid double taxation. He makes a point that there may be a difference between juridical double taxation and economic double taxation. Here we're concerned with juridical double taxation because it's the same entity being taxed on the same monies. But then just to note, although not directly material for this appeal, what does the Supreme Court look at? Well, paragraph 58, they look at context, i.e. the preceding conventions to the one that they were directly concerned with. And one can see that by turning the pages. So page 558, they look at the 1945 convention, paragraph 68 and 69. Paragraph 70, they also look at what the law was in the US. They look at a US Supreme Court case called Biddle. Turning the pages at 560, they look at the 1966 protocol as part of this exercise. And then there's a heading at 563, the first ground of appeal, Mr. Anson. And then just to note at para 93 that there were two possibilities on the basis of the arguments in that case about what was the same profits. One is that the provisions in relation to dividends adds nothing of substance. The second is that the existence of the provision implies that the underlying tax on dividends would otherwise be within the scope of the relief. At 94, he says, significantly, the first possibility is not initially attractive, and this is the point that you should be wary of concluding that a provision of the treaty has no meaning at all. And that's relevant to one of the arguments in this case in relation to Article 13 of the treaty. And then just turning on the pages at page 567, paragraphs 110, he adopts he identifies the correct approach to the present question, starting with Article 31 of the Vienna Convention, and then saying it is accordingly the ordinary contextual meaning which is relevant, and then referring to what Mr. Justice Robert Walker had to say in Memic, a treaty should be construed in a manner which is international, not exclusively English. And 111, that approach reflects the fact that a treaty is a text agreed upon by negotiation between the contracting governments. So we do place reliance on those paragraphs as well, 110 and 111. And then just two other cases to note quickly. Behind tab 25, there's a decision of this court in a case called Irish Bank Resolution. As we'll see in a moment, many of the double tax agreements around the world are based on the OECD Model Convention. And the OECD produces commentaries on that Model Convention, and those commentaries have changed over time. So one of the issues in Irish Bank was, were you entitled to look at a later commentary in order to understand what the parties had agreed at an earlier point in time? And what this court decides is, yes, you can, provided you're satisfied that the later commentary is merely confirmatory or explicatory of what was the position. But if you come to the conclusion that the later commentary is just different, then you shouldn't have regard to it. And then the last tab, tab 26, is the Supreme Court's relatively recent decision in Fowler, which again is a case about interpretation of double tax agreements. And this is the most recent word, we think, relevantly in the Supreme Court. about how one goes about interpreting these by reference inter alia to the OECD commentary. And it's paragraphs 16 through to 19 in the Judgment of Lord Briggs. And that is logic there harks back both to Anson and to Commerzbank. Now, I don't think those principles are in dispute between us, but there you have them. And perhaps if the point is raised again, I'll come back and deal with it in reply, but for my part at least, this court is both entitled and required to have regard to the French text. Two more points to note about the treaty itself. Whether the UK has, as the commissioners contend and the Upper Tribunal found, a right to tax here depends on looking at the treaty as a coherent whole. It also depends on respecting that it is an international treaty agreed after negotiation between the contracting states, each of them agreeing as sovereign states to allocate either exclusive or primary taxing rights between them. It's also useful to see, we say, by looking at other double tax agreements between these or other countries, what contracting states could have agreed but did not. A point I'll come back to in a little while, because there are agreements entered into, one by Canada with the US and one by the UK with the US, that tackle this sort of problem very differently. We say that is of some significance. But with that preamble, we need to look at this particular double tax agreement. So can I invite you to take up tab 4 in the first volume of authorities. This is to start with the English text. It was agreed in September 1978, page 42 of the bond. Entered into force in December 1980 with an effective date of 1976. Article 1 over the page 43, makes clear that it applies to persons who are residents of one or more of the states. Article 2 identifies that it covers Canada income taxes, and in the UK it covers corporation tax. It also covers petroleum revenue tax. And then Article 3 has general definitions in 3(1)a, definition of Canada. Roman 2, the definition of the United Kingdom, includes the continental shelf. So when one sees United Kingdom, one needs to think of that as including the UK continental shelf. And then over the page, page 44, there's a definition of an enterprise of a contracting state. And then Article 3.2, as regards the application of the convention by a contracting state, any term not otherwise defined shall, unless the contract otherwise requires, have the meaning which it has under the relevant contracting state. That's not going to be material here because we have a definition. We're not concerned with 4. Article 5 identifies what is a permanent establishment. It includes at little 2b a branch, and at little 2f a mine, quarry or other place of extraction of natural resources. Then over the page we find Article 6. I want to come back to the detail of Article 6 in just a moment. So can we skip on to 7? 7.1 provides that profits of an enterprise of a contracting state should be taxable only in that state. So a Canadian business is only taxable in Canada unless the enterprise carries on business in the other contracting state, here the UK, through a permanent establishment. So RBC does have a London branch, but this loan was not made through the London branch, so it is as if it doesn't have a London branch. And then 7.1 goes on, if the enterprise does have a permanent establishment, then you have to attribute the profits to it in accordance with paragraph 2. So we're not as concerned with 7.2. Then 7.4 provides where profits include items of income or gains which are dealt with separately in other articles of this convention, then the provisions of those articles shall not be affected by the provisions of this article. So that makes clear that if you have an item that is caught by Article 6, for example, then you get the treatment mandated by Article 6, irrespective of the treatment you would otherwise have got under Article 7. So just so you see the big picture, RBC has a banking trade in Canada. 7.1 tells us relevantly it's only taxable in Canada, but if it is taxable under Article 6, then 7.4 would tell us that 6 has priority. Turning over a couple of pages to 48, Article 11 deals with interest, and over page 49, in outline, 11.1 provides that interest can be taxed in the state of residence of the recipient. 11.1 is taxation in the state of residence. 11.2 also allows the contracting state of source to tax the interest, though often with a limit of 10%. And then 11.3 provides, notwithstanding the provisions of paragraph 2, and if we look at 3c, interest arising in a contracting state and paid to a resident of the other contracting state shall not be taxable in the first mentioned state, so no source state taxation, if the beneficial owner of the interest is a resident of the other contracting state and is dealing at arm's length with the payer.
Sorry, which paragraph are you reading from?
11.3c. So that's no source taxation as long as you're dealing with a resident at arm's length of the other state. But 11.4 says 3c doesn't apply to interest, all or any portion of which is, and read to the second line, computed by reference to, towards the end of that second line, commodity price. So there is a specific provision in Article 11 for interest computed by reference to a commodity price. And just to note, 11.5 makes clear that interest as used in this article means income from debt claims of every kind, whether or not secured by mortgage. One of the points that arises commonly when we come to look at Article 6 is whether interest secured on land is income from immovable property. 11.5 says no, it's not. It's dealt with under Article 11, not Article 6. But 11.4 makes specific provision where your interest is computed by reference to a commodity price. Over the page.
Sorry, how does that override Article 6? I mean, it says what interest is. But you're saying it has the effect that interest secured on land is only dealt with under Article 11.
Yes, that's, and we could turn up the commentary, but that's,
Right.
that's what the commentary says.
I see, it's the commentary.
Page 50, Article 12 deals with royalties. And that allocates taxing rights in relation to royalties in 12.1 and 12.2. But then 12.4 defines royalties as used in this article as meaning any payment, means payments of any kind received as a consideration for the use or the right to use any copyright, etc. And that language is relevantly the same as the language we will look at in a moment in Article 6.2. So just for now, can I invite you to underline or sideline that reference in 12.4 to consideration for the use or the right to use. And then,
despite being called royalty payments in the SPA, it's not suggested that these payments are royalties within the meaning of this article.
they are not.
No.
Because 12...
These are intellectual property.
They're intellectual property rights in all their guises,
Yes.
and we are not.
You're taking us to this purely for the use of the words here.
Yes, and that was misunderstood or misappreciated by the Upper Tribunal, who thought we were making a point about the definition of royalties, and we weren't. It was showing them that so we can see the significance of the language.
Thank you.
Page 51, Article 13 is of real importance to the dispute as a whole. 13.1 capital gains derived by residents of a contracting state from the alienation of immovable property situated in the other contracting state may be taxed in that other state. Immovable property is not defined in Article 13. It is defined for the purposes of the whole convention in Article 6. So 13.1 is dealing with the alienation of Article 6 immovable property. 13.2 deals with the alienation of movable property. 3 deals with ships and aircraft, not material. 4, gains from the alienation of A, any right, license or privilege to explore for, drill or take petroleum, natural gas or other related hydrocarbons situated in a contracting state, and then looking at the pull-out words, may be taxed in that state. So that's making specific provision for the license rights. And then 4b is making specific provision for any right to assets to be produced in a contracting state by the activities referred to in subparagraph A above, or to interests in, or to the benefit of such assets situated in a contracting state may be taxed in that state. So 4b is making specific provision for the right to the oil one. And then 5 makes specific provision for what happens if you sell shares in a company where most of the value is derived from various things. So 13.5a says shares other than quoted shares deriving their value or the greater part of their value directly or indirectly from immovable property situated in a contracting state or from any right referred to in paragraph 4 of this article, and then reading down to below B, may be taxed in that state. So 13.5a is significant because it deals with shares of a company that own immovable property and shares of a company that owns a paragraph 4 right. And that makes crystal clear that the paragraph 4 rights are not seen by the parties as immovable property. Now that's clear enough from 13.1, 2 and 4, but it's made crystal clear by 13.5.
I'm sorry, Mr. Peacock, you're going to have to say that again.
It is clear from the reference in 13.5 little a
Yes, just shares.
to shares deriving their value from immovable property or from a paragraph 4 right, that the paragraph 4 rights are not seen by the parties as immovable property.
I understand. Thank you.
And just to repeat, that's, we say, it's clear in any event from a close reading of 13.1, 2 and 4, but it's made express by 13.5a.
That assumes that it can't be both. I mean, in theory, you could draft something which says if it's immovable property, then you can tax it. If it's a right to take petroleum or the product, you can tax it. They don't necessarily have to be mutually exclusive, do they? Or do they?
Well, the parties are proceeding on the basis that they are.
Well, maybe going back to 4, I think you may be saying that, for example, 4B would not be necessary on the revenues approach. Indeed, you do say
I
that.
am going to say that.
Because 1 would cover it.
Correct. Now, I'm going to make a wider point about the need to read Article 6 with 7, with 13, with 27A. But the crux of it is a comparison between the scope of 6 and the scope of 13. And then just to complete the 13 exercise, 13.8 provides that if you alienate any other property, so that's not within 1 to 5, then it's taxable only in the contracting state in which the alienator is a resident. And then lastly, before I come to 6 itself, Article 27A, page 59.
When was this added? Is it? Because it's obviously an addition to the treaty.
A version of Article 27A came in 1980 in the first protocol by virtue of that statutory instrument I gave you the reference to.
Yes.
The version that's actually in here was amended again in 1985 by a further protocol. But perhaps relevantly for today's story, the treaty between the UK and Canada has made specific provision for a deemed oil PE since 1980. And what 27A does is to say 27A1, the provisions of this article apply notwithstanding anything else, so it's to override. And 27A2, the person is a resident of the contracting state and carries on activities in the other contracting state in connection with the exploration or exploitation of the seabed and subsoil and their natural resources, shall, subject to paragraph 3, be deemed to be carrying on a business in that contracting state for a permanent establishment. And 3 is a let-off if you have a short-term activity. So it depends on how many days in a 12-month period. But it's this provision that gives rise to a deemed permanent establishment in the UK if you have an exploration or exploitation activity in the UK continental shelf. And it is agreed between the parties that RBC doesn't have an Article 27A deemed PE.
But in the normal course, for a Canadian oil company operating in the continental shelf, this would be the way in, if you like, for the revenue to apply the ring fence.
To tax the profits of the exploration and extraction.
Because
yes.
deeming it to be a UK permanent establishment, therefore entitled to tax the profits under Article 7.
Yes. So when we come to think about Article 7, there's a question of whether RBC in its banking trade has an actual PE in the UK. And relevantly for this appeal, the answer is no. And does it have a deemed PE? The answer is also no. So if we then go back to 6, Article 6 confers taxing rights on the state of source of income, provided that income is from immovable property. And that is in 6.1. And we're told in 6.1 that immovable property includes income from agriculture and forestry. And the purpose of that is tolerably clear. There is a sufficiently close link between the income derived from agricultural and forestry and the land itself for that to be treated as being income from the land, the immovable property. And then 6.2 begins, for the purposes of this convention. One needs to interpolate the words, all of it, including Article 13. The term immovable property shall be defined in accordance with the law of the contracting state in which the property in question is situated. Now, it is not suggested that any rights that RBC has are immovable property defined in accordance with the law of the UK.
Well, there's a hint of that in the revenues.
They have a respondent's notice point that we fall within 6.1.
Yes.
I'll deal with that in due course, but it's not, it's a 6.1 point, it's not a first sentence of 6.2 point, as we understand it.
Well, I think it is, yeah.
Yeah, the corner of my eye, I'm afraid, is nodding, but let me deal with that in a little while. Second sentence of 6.2, the term shall in any case include, this is a statutory inclusion, or a treaty inclusion, and then one can split this next sentence up into a series of limbs. So property accessory to immovable property, and then one could mark a divide. Livestock and equipment used in agriculture and forestry, mark another divide. Rights to which the provisions of general law respecting landed property apply, mark another divide. Usufruct of immovable property, mark another divide. And then we get to the fifth limb, rights to variable or fixed payments as consideration for the working of or the right to work mineral deposits, sources and other natural resources. Now, if one looks at the commentaries such as they are on Article 6, that reference to property accessory to movable property was designed to cover things like animal feed. The reference to livestock and agricultural forestry equipment, fairly straightforward. If you have a tractor and you have income from a tractor, then that's caught. Reference there to livestock, we would commonly think of livestock as being movables, but they're treated here as immovables. So apparently once they die, they become movables again. There's another
Livestock then.
They are capable of being moved, but they don't move of their own accord. And there's another oddity, which we'll see in a moment, though nothing turns on this. The French text for livestock talks about them being live or dead. So there is an apparent difference on the face of it between the French text and the English text that one has to reconcile, but that's not necessary.
So only livestock that are alive are immovables.
On the face of the English text, that is true. Whether that's right as a fair reading of the treaty as a whole is not necessary. But anyway, livestock is deemed to be an immovable. Rights to which the provisions of general law respecting landed property apply. Again, if one looks in the commentaries and trace it back, that was designed to deal in particular with Italian landed estates. There was some concern in the 1920s and 1930s about property rights attaching to Italian landed estates. And so
Sorry, when you say that obviously that's not relevant to the UK-Canada treaty, but is that because the language as a whole derives from the OECD model?
It does, and if you trace where did the model come from, far enough back, you can find where where each of these limbs were first seen in a treaty.
But rephrasing it, there's nothing. Is it the case there's nothing sort of special about this definition in terms of the UK Canada?
No, this is
it's a standard version of the OECD
yes.
at the time.
Yes, absolutely standard. With one rider, which I'll come to in a second. But
Okay.
yes, this is a standard OECD model clause. The constituent elements of which you can, if one were interested, work out where they came from. We're not interested in any of this for the appeal. Usufruct of immovable property, obviously designed to deal with the civil law concept of usufruct. And then the one we are interested in is certain types of rights to payments, I'll put it neutrally, relating to natural resources. So what RBC have under clause 5.4 is a contractual right against initially BP and then later Talisman to sums of money. That is what an English lawyer would regard as a shows in action. The case against us is that shows in action falls in the fifth limb of 6.2. The way the argument proceeds is, well, the fifth limb deals with rights to variable or fixed, and this is variable because it's driven by the movement in oil prices. Those payments have to be consideration. Well, it said clause 5.4 appears in the SPA. It is part of the wider commercial deal between the BP company and Sulpetro. So it is consideration. But then it has to be for. So it's for, not in respect of, or some looser, broader phrase. It has to be for the working or the right to work. And I've made my point about working being payment per tonne or per barrel, and the right to work being payment by time. And it has then to relate ultimately to mineral deposits, sources and other natural resources, and we accept that oil falls within that phrase. But that phrase is not the right to acquire the natural resources, nor is it a right to a payment computed by reference to the sale by someone else of the resources so extracted, here the oil one. I need to develop that a little further. If we then just look on at 6.3, the provisions of paragraph 1 shall apply to income derived from the direct use, letting or use in any other form of immovable property. It's direct use, letting or any other use, and to profits from the alienation of such property. So one might pause there and think, well, how does 6.3 deal with alienation when Article 13 clearly deals with alienation? And the answer lies in the word profits. 6.3 is designed to deal with a person who makes a dealing profit, i.e. not a capital gain, a dealing profit from the alienation of immovable property. So if you are a trader in land or a trader in the rights identified in 6.2 and you make a profit, then that falls within 6.3, because what you make is an income profit. If it's a capital transaction, then one must look to Article 13. And then 6.4, not material, but the provisions of 1 and 3 shall also apply to the income from immovable property of an enterprise and to income from immovable property used for the performance of professional services. So even if your Article 6 income is part of an enterprise or a professional service, it still falls within Article 6. So the debate between the parties ultimately boils down to this. Does the shows in action that RBC holds under Clause 5.4, as against BP and then later Talisman, amount to a right to a payment given as consideration for the working of or the right to work Buchan? Now, we say no, the right to work Buchan was in SUKL, which passed by the sale of the shares. The working of Buchan was done by SUKL, it wasn't Sulpetro. And the payment that BP agreed to make to Sulpetro, which was then later made to RBC, was not consideration for such rights. And that, we say, gives meaningful effect to Article 6 in this appeal, but also gives coherent effect to Article 6 when read with Article 13, such that if you make a capital gain on an oil right, you are taxed in accordance with Article 13. If you derive income from the grant of the right to work, you fall within Article 6. As a non-resident that does not fall within Article 6, you are then either only taxable in Canada if you have no actual or deemed permanent establishment in the UK, or if you have either of those, you're taxable in the UK.
You say the last part, then you're only taxable
In Canada,
yes,
unless you have an actual or a deemed permanent establishment in the UK.
By deemed, you're referring to
Article
Article 27A.
So if you're an Article 5 actual permanent establishment or an Article 27A deemed one, you're taxable in the UK. And that is a perfectly sensible, coherent structure for Article 6 when read with 13, and then both of those read coherently with Article 7. And we've set that out in summary form in paragraph 37 of our skeleton. And there is a longer explanation that was an appendix to our Upper Tribunal skeleton. I'll just give you the note to that. It's in the supplementary bundle, tab 22, pages 294 and 295, where we identify the different types of transaction that would be taxable under either 13 or 6 or 7. Now that then takes me, admittedly slightly longer than I thought it might, to my fourth heading, which is, well, what's the proper interpretation of Article 6.2? This is ground one of our appeal. So I'll just give you the headline. We say Article 6.2 is limited to income derived by the grantor of the relevant right. In such a case, but not otherwise, the income is received from a right to payment, which is consideration for the right to work. We say the person who owns the land that contains the mineral resources could work that resource him or herself, and that would be 6.1 immovable property income. 6 also needs to deal with this circumstance where the owner doesn't work the resource itself, but confers the right to work the resource on someone else by granting a license or a right to work, That right is granted for payment, whether that's expressed by time or by unit extracted. That is a payment that is consideration for the working or the right to work the resource. And that perfectly sensibly gives effect to 6.2, because in economic terms, the owner has given up the right to work the land themselves and conferred that right on someone else in return for payments, those payments being consideration for the right to work and falling within 6.2. I pause there just to give you another reference. There is a famous to tax lawyers and largely impenetrable book that was originally written in German called Vogel on the interpretation of double tax treaties. And it has been translated into English. I'm afraid it reads as if it's been translated from German into English. So it is a tough read. But just for your note, in volume 3 at tab 34, it's in particular paragraphs 127 and 128 that explain at least what the authors of Vogel think Articles 6.1 and 6.2 are doing.
Are you trying to draw an analogy with rent here? Because this concept of income arising to the grantor is not a straightforward one, and obviously the revenue pick up on that. But is the concept you're trying to get to something that's effectively closer to the land? So what I'm thinking about is grant of a lease for rent, plus possibly premium, quite obviously income from land.
Yes.
What happens if the lessee could then either grant a sublease himself, again they might get rent, or they could potentially sell their interest. And possibly part of the consideration for that might be a stream of payments that might be income, but wouldn't be rent. Is there an analogy there that assists?
We say yes, provided that then one categorises the receipts of each of those parties in treaty terms. So the simple head licensee granting to a sub-licensee,
Lessee, I think.
sorry, a lessee,
Yeah.
would be an Article 6 transaction. So the income in the hands of head lessor and sub-lessor are both 6.1 streams of income because they're from the land.
Yes, and in English law terms, that's rent. It's understandable.
Yep.
It's an understandable concept.
If you sell the benefit of your rights, try not to beg any question, if you sell the benefit of your rights, and let's imagine you do so in consideration for a series of payments, we say that's not an Article 6 transaction, it's an Article 13 transaction.
Well, if you made an income, if you made I think given what you said earlier, if I sold my rights for an income profit because I was a dealer, that might fall within.
My lady is right, I'm assuming you're not a dealer. If you're a dealer, then 6.3 definitely covers you. But 6.3 is important because it draws a distinction between the dealer who makes a profit and the non-dealer who makes a capital gain.
Yes, I wasn't really getting at that distinction, more at the sort of quality. Your point about grant is something to do with the nature of the payments and the quality of the payments.
Correct.
And I was trying to explore that.
And it is, there is a helpful analogy with rent. Now, I don't want to be taken to say that Article 6 can only deal with what an English lawyer would call rent. I'm not saying that.
No, we're just trying to understand the submission.
Ultimately, the divide between the parties is, we say, read in context, that reference in the fifth limb to 6.2 as consideration for the working of the right to work, deals with the person who's granted that right. If you're a transferor of that right to somebody else, you're dealt with under Article 13. And that's our ground 1. If we're right about that, then 6.2 doesn't apply here. Just by way of headline, if you're not persuaded by that, so 6.2 could apply both to a grantor and a transferor, our ground 2 says we step into the shoes under clause 5.4 of Sulpetro.
Yeah.
Sulpetro didn't transfer.
Yeah, no,
the
we're
work
dealing
in
with.
right work.
I know we're dealing with ground 1 here.
But just so you see the big picture, that if we're right about this, we don't get to ground 2. If we're wrong about this, we have a high quality answer on ground 2.
Is that a convenient moment, Mr. Peacock?
It would be, yes.
And you're going a little bit more slowly than you'd hoped. I'm sorry if that's us.
No, I suspect it's entirely me. I am just a little behind, but not more than I would suspect 5 minutes or so.
Excellent. Thank you very much. On that basis, then, we'll say 2 o'clock.
All rise.
A lot of